Asher, thank you for taking the time to speak to me today. Excited to sort of hear a little bit about you and what you've been working on. And maybe we can start with the Advocates for the Rule of Law and the letter that was sent with yourself and a group, I think, of lawyers and other intellectuals on, challenging the federal government's Emergency Act. You want to tell us a little bit about the Advocates for the Rule of Law?
Sure. And first of all, thanks for having me on, Joseph. Advocates for the Rule of Law was founded, I guess, 8 years ago now, back in 2014. I just thought about it. It occurred to me it's been almost a decade now. Time flies when you're having kids, and the reason I founded it was multifaceted. Some of it had to do with my practice and what I was witnessing in terms of judges not always applying a rule-based approach to issues, deciding cases based on what they felt was right, and which is nothing new, but that started making me more impassioned for a more rule of law approach. So certain things like that. I also went back and I read the Persons decision, the famous Edwards case where the living tree metaphor comes from, and I was astonished when I read that that the case did not say anything close to what I had been taught in law school that it says. In fact, it was a very dry, if I may say, rule of law type case, and that made me think that, what, there's an orthodoxy in this country that is not really being challenged, and that orthodoxy is in many instances leaving behind what had been orthodoxy, and what I would submit is the historical Canadian approach to things like statutory interpretation, things like development of the common law, this more rule of law approach. And so I and some other people got together and we made this group called Advocates for the Rule of Law. And it started out as sort of a glorified blog where different people were posting articles about different cases and their take on it, trying to inculcate more of a rule of law culture. And then I think it was 2017 or 2018, we began intervening at the Supreme Court in certain cases. And we always take on what I would call structural cases that have to deal with, things like separation of powers, stare decisis, really big issues, not policy issues, if I can sum it up that way. And so we do some interventions. We've done some CLEs. We still publish, and now, as you were suggesting, we've written a letter.
So tell me about the founders. Were there 5 of you, 6 of you, or was it 2 or 3 of you at the beginning? And now, has it grown? Is it like a membership style? Is it really just an alignment of interest with other lawyers that want to potentially learn more about it? And we should get you to share the website.
Oh, sure. Yeah. The website's really easy, ruleoflaw.ca. I think there were about 4 or 5 at the beginning. There's more now. Some have dropped off and then new ones came on. It's now an incorporated, it became a not-for-profit, I want to say, in something like 2015 or 2016. Then it became a charity in 2019. So it's a registered charity now. It has, I think, 6 directors. It has 5 or 6 officers, and there's not complete overlap there. I'm one of the only officers and directors. And then it just has some other members who I say are sort of executive members. They come to our executive meetings. They help with day-to-day running of it. And
it's really taken off, and which is awesome to hear, and sort of been a slow but steady. And then all of a sudden, you found yourself at the Supreme Court of Canada. I think that's fabulous. I guess I'm wondering why there was a need for the Advocates for the Rule of Law. It almost suggests that the rule of law, then there was some form of an erosion of the rule of law or concerns around what you were seeing, and so this was the impetus. Is there anything? Can you sort of clarify if that was if I'm hitting it on the head or I'm off a little?
Yeah. So I would not have started this group if I didn't think that the rule of law culture still permeated our legal system very strongly. If I thought that that fight had been lost, I would have just said, well, put up the white flag. There's no point. So what I was seeing was not necessarily an erosion of the rule of law, but a threat to the rule of law, a potential erosion of the rule of law. And what I saw at that time was that if we don't take steps now, we will get an erosion of the rule of law. We're starting to see it at that time more and more in Supreme Court of Canada decisions where it was like the living tree on steroids almost, where the natural limits part of that metaphor was no longer really even factoring in, and where you really were seeing a more policy-driven approach, in my respectful view. And then even in sort of day-to-day civil litigation cases, I was seeing decisions that would just frustrate me a little bit as someone who cares about things like predictability. And it was difficult for me as an advocate to advise my clients sometimes, because I would say to them, look, I got to be honest with you. I don't know how a court's going to go here, because one court went this way, but the other court went this way. And when the facts are sympathetic, you just don't know, as that old saying goes, hard facts make bad law. And, I don't approach the law as a robot. I understand it's a human institution. You're dealing with real people with real problems, and there's always going to be some element of that. But we do need rules, and we do need principles that are applied predictably and consistently over time. And that fundamentally was the impetus behind ARL.
Awesome. And so tell me, how does that connect with, because I know you're involved with Runnymede Society. Is there a natural progression? What was the idea behind Runnymede, and sort of how did it progress from where you started?
Yeah, so ARL was never, or I shouldn't say was never, but it became evident early on this was not going to be this massive big tent group. It was more like a group of a few very interested people who like to write, or who are very engaged on these issues. And in 2015, so about a year and a half after we started ARL, I got in touch with Marnie Subkoff, who was then leading the Canadian Constitution Foundation, and we decided that we wanted to make a second group that would be more of like a big tent. And right away we were coming up with names, but all the names we were coming up with, society was in the name. And that's what I remember from our first meeting, that this was going to be a society. It wasn't going to be surgically targeted like ARL, where it's about, writing articles and going to the court. This was going to be a student-led group where people of different persuasions are coming into it, and we're going to be debating a lot of ideas. Yep. And with an emphasis on rule of law and constitutionalism and those values, but really bringing it to students for the first time. And if you think about it, Runnymede is sort of like the first year seminar course, and ARL is sort of like the upper year specialized course in a way. That's how.
I think it's great. I attended one of the events a while back. I think it was Claire Lemon, the author of Quillette, was speaking, and there was a debate, and I thought it was fabulous. And I hear that Alexander Wilkes is involved in a debate. I think it's this weekend is the next Runnymede event, if I'm correct.
Yeah. So candidly, I'm I think affectionately referred to as the absentee father of Runnymede. So I was there very prominently at the founding. I was Marnie and I founded the group. We came up with the name. We then hired Joanna Barron, and then after we hired Joanna Barron, my involvement really took a backseat. She did an excellent job getting this thing off the ground. It was like a startup, and she got us on a ton of campuses right away. Then Mark Mancini came along, and I think he really brought a lot of new ideas, and he really took us up a notch on the academic and scholarly rigor side of things. And now Chris Kinsinger has taken over as our third national director, and he's been excellent getting like a ton of events going. So just to your question, he's had so many great events over the last few months. I candidly can't even keep up with them. I've done one in the last month myself, and then I'll be on one of the panels at the upcoming conference, March 11th and 12th.
Great, 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 great. Awesome. All right. So let's talk a little bit about the Emergencies Act, if you don't mind, switching gears, because this,
Sure.
ARL, the Advocates for Rule of Law, wrote a letter, and I guess I can characterize it as raising serious concern about the actions of the Trudeau government. And maybe you can tell us a little bit about the letter and what type of reactions you were getting from the from the lawyers in your community and maybe others, just generally.
Yeah, sure. Well, I mean, the letter responded to the government, the federal government's invocation of the Emergencies Act, and a bunch of us at ARL got together and we kicked around some ideas about what we thought about this. And it was important for us to be charitable to the government. I didn't want to, take the position, certainly that there was nothing wrong going on, that there was no problem that needed to be addressed. I had actually been vocal on Twitter up to that point that that the governments, provincial and federal governments, weren't doing enough. That we weren't seeing police ending these blockades. That was a big concern of mine, actually. And I didn't want, the government published their 14-page explanation, and I wanted to give them 100% the benefit of the doubt that everything in that explanation was accurate. And my point, and the point of the others who signed on to that letter, was that even taking everything the government is saying at face value, you're still not meeting the stringent test you need to meet in order to justify the invocation of the Emergencies Act. It is such an extreme measure to take, and you have basically come out by invoking this act, you basically come out and said we're facing a terrorist threat, but your own explanation simply does not justify that. Your own explanation says, yes, we have problems at our borders. Yes, we have illegal blockades. Yes, there's the threat of violence even. Yes, we have seized some guns, but nothing to suggest that there were threats to the security of Canada, which another statute that is related to this, the CSIS Act, defines as essentially a terrorist type threat, where you have.
I saw that you went to the CSIS Act or whatever it's called. Maybe I'll post that in the notes. But and you specifically looked at what's defined as a terrorist act and looked at it from that perspective.
Not what's defined as a terrorist act. So the Emergencies Act says that threats to the security of Canada, which you require in order to have a public order emergency, they say if you want to understand what that term means, you go to the CSIS Act, and it has the same definition as that act. That act has 4 potential pillars of what could be threats to the security of Canada. One of those, and the one that the government hung their hat on, is it doesn't say terrorism, but it's the terrorist type threat, threats of serious violence to persons of property motivated by ideological aims. Yeah. That is terrorism, essentially. And I just was not seeing that threat, and I certainly wasn't. You tend to think that these things would manifest fairly early on, so I certainly wasn't seeing any evidence or even an allegation of that threat. 2 weeks after this thing begins. In fact, it seemed to me, and it seemed to the other members of ARL, that things were calming down. The issue at the Ambassador Bridge, the issue at Coots, these blockades had already been dealt with very peacefully. So there was a sort of, if I could use that old reference from the 80s, there was a sort of where's the beef objection to all this. Where's the terrorism?
The what are we missing? What is going to be in the explanation or the notes or in the consultation with premiers that we don't know, or along those lines? Yeah, very interesting.
Yeah. Well, and the letter, again, trying to be charitable to the government, because emergencies are very serious, and it's important for a group like ours that is founded on the rule of law to understand that the rule of law can only be maintained where there is security. To use the term in our Constitution, peace, order, and good government. That is a fundamental prerequisite to the rule of law. So we're very sensitive to national security issues, and so trying to be charitable and generous to the government in that way, our letter concludes by saying, look, if you do have something, if you have intelligence, and maybe you do, and if you do and you haven't shared it because it's sensitive, then you need to say so, and you need to speak with key members of the opposition who can be trusted in confidence not to share that. We need to deal with this as adults. In other words, we can't have this be the standard question period where sound bite questions are asked and non-answers are given. We need a grown-up level of discussion and debate about this, if it really is that serious. But if not, you've got to end the invocation of the act now.
Yeah, certainly you can argue this is one of the more important events that we as lawyers with the privilege of being able to practice law should be looking at and considering. I mean, historically, we haven't seen anything like that. I mean, these last 3 years, we haven't seen anything like in terms of considering some of the issues around fundamental rights and freedoms and the rule of law. So definitely fascinating. Had you got any response to your letter from the government, and have you gotten any response or anyone upset as a result of you sending your letter out? And is the letter on the website? Let's make sure we, if it's there yet.
So the letter, I was meaning to add the letter to the website. I've just been so busy this week. It's on my to-do list for this weekend. The letter was published though on the Hub.
Yeah.
Very, very incredible national publication that is new. Sean Spear and some others run it. So if you Google the Hub and Google our letter, it'll come up. And because it was published on the Hub, I sort of said to myself, well, it's there. I can wait a couple of days before I put it on the website.
Tell us about the reaction. Tell any specific.
Well, the government, I mean, we never heard from the government. We did hear from individual members of parliament. Scott Reed referred to it in his remarks to the House. Senator Batters referred to it in her remarks. We heard from the offices of some other parliamentarians that they had read it and had definitely taken it in. The response generally, I think, from the legal community, if I might call it that, was positive. Some people, there was the one sort of negative response we got wasn't that you're wrong so much as it was, isn't it convenient that you're talking about this now as a rule of law issue? What about the failure to enforce the law before that? Isn't that as important of a rule of law issue? The response to that was, first of all the people who had signed on to this letter had
expressed a view to the position that the government should do more to stop the blockade or.
We had definitely taken that view, but I think what the other point is that I think what some people might not realize is that this is still a small group, and it's nobody's full-time job or even anybody's part-time job, and certainly not mine. And I had a tweet that sort of reflected this. Like, I thought it was pretty good that I was able to draft, one letter, and the notion that we should have had all these other letters for different other rule of law issues that arise from time to time. I was pretty pleased that I was able to get one letter out for what was a completely unprecedented move by the government.
Yeah, and so I mean, yeah. What and I don't want to get into the. I understand that the, Canadian Constitutional Foundation, the CCF, has brought a challenge, and the CCLA, the Civil Liberties Organization. I think those are judicial review applications. I'm not sure that they're direct charter applications that specific to, what, let's say, Jason Kenney might do, like a province or a premier. What do you think the role should be for lawyers sort of going forward over the next 60 days when an inquiry happens, and, in general, as a result of these actions? Because the fear is this whole slippery slope idea that once we open these doors and allow this to happen on sparse grounds or potentially sparse grounds, we don't know all the information, is that going to open the floodgates, as they say?
Yeah, well, I mean, I think it's great, of course, that we have a system where you can judicially review government actions like that. There's also going to be an inquiry, as I understand. I have litigated constitutional issues. ARL has gone to the Supreme Court in its capacity as intervener. So I obviously believe that courts play a role in this. But fundamentally, and this is a point that we make in the letter, it's a point that I've made elsewhere in writing. The rule of law is only safeguarded if you have dedicated citizens. And courts are not going to be able to prevent governments from acting outside their jurisdiction. Courts are not going to be able to prevent all violations of rights. They can prevent some, but not all. The reason is that things move quickly, especially in 2022. Things move very quickly,
Yeah.
and our courts move slower than ever. And by the time a matter gets to court, it may have become moot. And if it's not moot, the damage may have been done already. And that really motivated me to get that letter out, because I thought, yeah, this would be a great file for me if I get retained by some group, and I can say, hey, I'm the lawyer for so and so, we're going to court. But really, the best way to attack this is not on the back end, it's on the front end. With not legal advocacy, well, not courtroom legal advocacy, but public legal advocacy.
I love it. That's great. I really appreciate that. And again, so if anyone listening wants to sort of follow you on social media or get in touch with you, give us your firm website, your Twitter and your LinkedIn handle. And I'll also post it for those that are listening in the notes as well, if anyone wants to take a look from there. But go ahead.
Yeah, absolutely. My firm is Jordan Honickman Barristers. My first name is not Jordan, contrary to what many people call me looking for a lawyer say. It's Jordan Honickman. My partner's name is actually Michael Jordan, so that's easy to remember.
Even better. Yeah.
And the firm is jhbarristers.com. And on Twitter, I'm at Honickman. And LinkedIn, I think it's just Asher Honickman.
Awesome.
So yeah,
I appreciate this, and I appreciate the time and the insight on it. And I think it's awesome the work you guys are doing, and really glad you took the time to kind of come on and explain to us sort of some of the things you've been doing and the reactions you've been getting. That's great. Thank you again.
Oh, thank you for having me. Great.
Thank you.